Once again, good afternoon, everyone. Welcome to first LAWVS National Moot Court Competition 2025. We are now assembled here for semi-final round. The court now in the session of semi-final round for first LAWVS National Moot Court Competition 2025. The petitioner side is Team Code 17 and the respondent side is Team Code 14. It's my pleasure to introduce the honorable bench for this round. We are honored to have you with us, sir. Sri Deepan Merchant ji sir, a senior advocate Deepan Merchant sir has been practicing for more than 40 years and has been appearing as a senior counsel in Supreme Court and various high courts in India. Respect respect of commercial matters, PILs, writ petition, arbitration, SLPs, and matters pertaining to Bombay Municipal Corporation as senior counsel. He is he is panel senior advocate for public sector like ONGC, JNPT, Bharat Oman Refineries, Municipal Corporation of Greater Mumbai, and other big institutions. He is also senior counsel for SEBI for last several years and a panel senior counsel for State of Maharashtra. Thank you for coming here, sir.
Thank you.
And second, and the second judges for this panel is senior sir. The second judges for panel is Sri Narendra Kumar Goswami ji, advocate, notable lawyer, Supreme Court of India, former Air Force officer, environmentalist, motivational speaker, social reformer, and appearing in various High Court of India. We extend a warm welcome to our honorable judges and thank for their valuable time and graceful presence for the evaluation of semi-final round. I would like to introduce the instruction for both the teams. Each team shall get 30 minutes for the oral submission. The time division between the council must be informed to the court before beginning. Rebuttals may be requested from the bench at commencement of arguments. The court serves the discretion to extend. It is pleased the honorable bench. May I now request the council for petition to begin the submission?
Yes.
Greetings, my lords. My lords, am I
Yes.
audible?
Yes, you're audible.
Yes.
My lords, the counsel for petitioner seeks permission of the court to submit its case.
Yes. Permitted.
My lords, the time division between my co-counsel and me will be 15 minutes each.
Okay.
My lords, if it pleases the court, my lords, may I take a brief moment to acquaint the courts with the facts of the case?
Yes.
My lords, the ancient Banke Bihari Ji temple in Vrindavan stands as one of India's most sacred spiritual temples, welcoming over 50 lakh devotees annually within its historically evolved heritage precincts that consists of devotional pathways and culturally significant structures. Following the tragic stampedes, my lords, on 19th August 2022 during Janmashtami, PIL proceedings under 226 sought judicial intervention for devotees' safety. The state's response to that was the ambitious Baki Bihariji Temple Corridor project, my lords, which proposed comprehensive demolition of over 300 heritage precincts across 8 acres of historically significant land. My lord, the Allahabad High Court's judgment of 20th March 2023 mandating project execution emphasizing public safety has triggered this constitutional challenge, my lords. The petitioner MX Govindas represents hundreds of displaced families whose fundamental rights under Article 14, 21, 25, and 26 face imminent violation. My lords, this case concerns constitutional protection of heritage, environment, and fundamental rights against disproportionate state action which is masquerading itself as public safety, my lords. My lords, without wasting much time of the courts, if my lords would allow, I would straight on jump to the first issue of contention, my lords.
Continue.
My lords, the first issue is whether the validity of issuance of mandamus with respect to 226 of the Indian Constitution is valid and whether such issuance of such writ constitutes micromanagement. My lords, at the premise of petitioner's argument is the assertion that by the issuance of such writ, the court has vehemently ignored the constitutional framework which enshrines the separation of power as an unavoidable feature under the basic structure doctrine, my lords. My lords, this was also firmly established in Keshwananda Bharti, my lords, and something that is also established by the virtue of Article 50 of the Constitution, my lords. My lords, Article 50 mandates separation of judiciary from executive in public service and policy matters, my lords, creating an indispensable autonomy that cannot be abrogated through constitutional amendments, my lords, much less through judicial discretions. My lords, the kind of judicial intervention that we are contending here is that we agree to the fact that when an administrative body fails to perform a public function, the court shall issue the writ in response of a PIL, if and when it is filed. My lords, and I use the word shall herein with my lords with great caution, because the court, in a scenario where there is ample proof of breach of fundamental right, it is obligated, my lords, by its constitutional duty to issue such writ. But my lords, what the court cannot do is tell the administrative body to come up with only a specific kind of scheme, my lords, which it did herein by directing the state to come with the corridor scheme, my lords, which was a direct directive. My lords, this bypassed the state at which the government has to apply its own prudence, which is done through consultation of stakeholders, which is also absent in this case, my lords. My lords, we are not contending that the rate which was issued was wrong. However, my lords, the nature of the issuance is what makes the difference. Mandamus can compel this duty, but prescribing the correct, accurate corridor scheme to the state itself and ordering specific demolition, my lords, goes beyond compelling duty to dictating methodology, my lords, which violates the principle that the court cannot issue mandamus to frame policy, my lords. My lords, if the executive proposals were inadequate in any case, the proper judicial response would have been to reject them and direct a better compliance with that to meet constitutional standards, my lords, not to substitute them with judicial preference. The court could have said ensure specific corridor safety measures meeting specific standard benchmarks, the benchmarks which, my lords, the court could have and stated rather than approving a particular corridor scheme, my lords. My lords, this could have maintained judicial oversight while preserving executive autonomy in implementation. My lords. My lords, the constitutional scheme envisages a threefold division that we are all aware of. The executive formulates and implements policy, and while the judiciary exercises review without usurping executive functions, my lords. My lords, infrastructure development, urban planning, and crowd management fall squarely within the executive's constitutional remits. The High Court's mandamus, which directs a specific corridor implementation, transgresses this framework, my lords, by encroaching upon the executive's exclusive domain of detailed policy formulation and administrative oversight. My lords, while Article 226 confers broad powers, these powers are not unlimited, my lords. Courts must exercise judicial restraint and refrain from encroaching upon executive or legislative domains, my lords. The Supreme Court has consistently affirmed that courts cannot issue mandamus, compelling the state to frame or dictate policy, my lords. While 226 empowers courts to annul subordinate authorities' acts, it doesn't extend to substituting court's own decision to the state, my lords. My lords, the Supreme Court has jurisprudentially proven that courts cannot issue mandamus compelling the state to frame or dictate policy, because this in itself, my lords, is a breach of the basic structure doctrine. My lords, executive decisions concerning policy formulation and resource allocation are answerable through democratic process of election, my lords. Judicial substitution erodes this democratic principle that policy choices are determined by elective representatives or their appointed authorities, my lords. My lords, before moving to the next issue, I would like to draw the court's attention to the written submission of the respondent, my lords. In this case, if the court has access to the same, my lords.
Sorry, which one?
My lords, the written submission of the respondents, my lords.
1 second, I'll just say that. Okay, you can continue.
My lords, on page number 14, in para 2, my lords, the respondents quote a judgment which is L. Chandra Kumar versus Union of India, my lords, in which not me, my lords, but they quote, and I quote, my lords, they state that Supreme Court held that where the executive authority fails to discharge their constitutional obligation, courts are empowered to issue directions to ensure effective governance, my lords. My lords, I would like to reiterate that they are the representatives of the executive, my lords. The question that I want to ask to the court, my lords, toward this is that by making such a submission, are they contending that their client, which is the state, is so incompetent that they can't seem to decide which policies to formulate and which to not? At
First,
this point, my lords,
sorry, first an advocate cannot put a question to the court. You can never put any question to the court.
my sincerest
But
apologies, my lord.
yeah.
My lord, secondly, another statement that troubles my conscience and I think would also trouble the conscience of this honorable courts is on my lord's page number 16 under the subheading 1.3.
Yes.
The second line, my lords, itself in itself, where they contend, and I quote, that in India the doctrine of separation of power is not absolute in the strict sense. My lords, if the separation of power is not absolute, then what is, my lords? I think by making such a statement, the council is not only ridiculing the jurisprudence of Keshwananda Bharati, but the constitution which embodies the separation of power. My lords, the absolute next line to that states that while legislative, executive, and judicial functions are constitutionally distinct, the Supreme Court has consistently held that the judiciary may intervene when the executive failed to discharge its constitutional duties or inactions threaten fundamental rights, my lords. My lords, what these states, my lords, is that while I agree with such directions are actually constitutionally mandated, but this ignores the distinction that lies in the nature of the intervention, my lords. Specific problems, my lords, require specific standards to be set by the judiciary, not specific solutions which are to be spoon fed by the to the executive by the judiciary, my lords. And by contending what the respondent is contending by such statement, they are contending an absolute ignorance to procedural laws and jurisprudence, my lords. My lords, if the court is satisfied with the first issue, I might move on to the next. May I move on to the next issue, my lords?
How do you apply Keshav and Bharati to facts of this case?
My lords,
On what basis?
Keshwan and the Bharti entails the basic structural doctrine itself, my lords. My lords, the part
No,
of
I'm
basic
sorry.
structure.
I'm sorry. What I want to say is, how do you equate that the facts of this case? I'm talking about the particular facts of the case, the situation which had arisen at that particular time, where the court had to intervene. How do you equate that with the Keshav and Bharati case?
My lords, separation of power in itself, my lords, is a part of the basic parts of the constitution that has been recognized by the Keshan and the Bharati, my lords. My lords, my lords, any judgment, any order that is issued by the court must operate within the constitutional bounds which are established by the basic structure doctrine, my lords. My lords, the High Court crosses this
So
by.
therefore, show how is this judgment against the Constitution? What is wrong? Show me those parameters where you feel the court was wrong.
My lord, certainly. My lords, the High Court crossed from reviewing executive action to directing a specific policy, my lords. This transforms judicial review into a judicial administration, my lords, violating the the basic structure doctrine that was established by the Keshwananda Bharti.
Right. Okay, next.
My lords, if I may move on
Yes,
to the next issue.
Yes.
Much obliged, my lord. My lords, the counsel for the petitioner contends that the impugned order directing reconfiguration of temple approaches, alleys, and religious circulation routes constitute a grave violation of Article 25 and 26 of the Constitution, my lords, warranting immediate intervention by this honorable court. My lords, Article 25 and 26 guarantee religious freedoms as lived faith encompassing rituals, observances, ceremonies, ceremonies and modes of worship essential to the community. My lords, the Supreme Court in the Shiruri Math case affirmed that matters of religion encompass doctrine, dogma, bhakti, karmkands, bringing communal practice within Article 26B's denominational management protection manuals. My lords, the Shiruri Math decision crystallizes the essential practice doctrine, stating that a ritual is essential if the religious nature would be altered without it, forming belief and worship's keystones, my lords. My lords, this doctrine vests denominations with exclusive authority to identify indispensable rites and ceremonies from scriptures, traditions immune to external displacements, my lords. My lords, the reason why we are contending that traditional temples approaches and circulation routes meet this essential criteria is not because of some arbitrary logic or emotion, my lords. My lords, in the Bhagavata Puran, which describes these circular routes and these galyas and alleyways of Vrindavan, wherein Krishna Leela was performed, there is a chapter, my lords, dedicated to the importance and to the cultural significance of these alleyways, my lords. My lords, additionally, their essential character is further proven by people's belief that have been continuously observing these alleyways as sacred for centuries. For centuries and are inseparable from the darshan experience, my lords. My lords, the Supreme Court recognizes that entire temple precincts must be held sacrosanct, where well-established Hindu temples worship principles exist with agnic backing. And my lords, the counsel for the petitioner provides this agnic backing to the court. My lords, therefore, traditional temple circulation routes qualify as integral religious practices forming settled worship patterns, my lords. My lords, Article 25(1) guarantees freedom to practice religion anywhere, my lords, extending protection to religious activities without locational confinement. Therefore, my lords, the proposed reconfiguration fundamentally interferes with this by altering traditional sacred spaces, approaches, modes, contradicting Supreme Court's recognition that religious freedom encompasses all acts done in pursuance of religion and constitutional assurance that religion may be practiced anywhere. My lords, states' interference in religious affairs faces strict constitutional limits under 25 and 26. Intervention requires clear demonstration that denominational rights threaten public order, morality, or health. This high threshold, my lords, demands compelling interest before constitutional intervention in a religious practice. Regulatory powers, my lords, must not unduly infringe protected freedoms or amount to previous and absolute restraint on religious expressions, my lords. This was also stated in the case of Vijay Emmanuel versus State of Kerala, my lords. My lords, where less restrictive alternatives achieve legitimate state's objective, constitutional principles require their adoption over intrusive measures such as demolition, my lords, which has happened in this case. My lords, administrative law also mandates least restrictive alternatives when limiting fundamental rights. Where, my lords, the crowd control and enhanced security protocol or phased access systems address safety concerns without permanent structural altercation. Constitutional principles require their adoption, my lords, over intrusive reconfiguration, which is what is happening in this case. My lords, religious rights require procedural.
We can hear you. Something wrong with the net. We can't hear you.
Team 17, speaker 2 can continue.
Am I audible, my lord?
Is audible now.
Yes, you're audible now.
Sincerest apologies, my lord.
Yes.
My lords, religious rights require protection through meaningful consultation and participatory decision making. Absent adequate denominational involvement, my lords, which is the administration of this temple in reconfiguration planning, violates natural justice principles governing fundamental rights restrictions, my lords, which is also stated in the case of Anuradha Bhasin versus Union of India, my lords. My lords, the state's unilateral reconfiguration in this case, therefore, transgresses constitutional guarantees of freedoms by irreversibly altering essential religious practices and encroaching upon denominational management rights without satisfying exact standards of necessity, proportionality, and without satisfying the least restrictive means, my lords, which were absent in this case. It is therefore.
Is it correct that the court also considered expert reports before passing an order?
My lords, while the courts considered expert reports before passing orders, my lords, these were not least restrictive means, my lords. That is what the counsel for the petition.
Now, what was the thing about the order reports which were saying? What were the reports saying? Which weighed with the court? Are you aware of that?
My lords, the counsel pleads ignorance of the same.
Okay, fine. Go ahead, continue. No problem.
My lords, it is respectfully submitted that this honorable court set aside the impugned order and direct the state to adopt less intrusive alternatives that preserve constitutional and religious freedoms while addressing legitimate safety concerns, my lords. My lords, at this point, if the court has any question with regards to issue number 2, my lords, the counsel for petition would be more than happy to answer.
No, fine, you can continue. No issues.
My lords, I am done with my first and second issue. I would request my co-counsel to continue with the third issue.
Okay, thank you.
Greetings, your lordships. If I may have the permission of the court to continue with the third issue.
Yes.
Much obliged, your lordships. Counsel for the petitioners would like to submit, your lordships, that the state's objectives of crowd management and public safety do not justify the large-scale demolition and redesign of the organically evolved sacred precincts, since less restrictive alternatives are effective. My lordships, the Banke Bihari temple precinct is shaped by centuries of continuous religious practice, traditional lifestyle, and community interactions. The loss of such organically evolved heritage precincts, lordships, translates into an irreversible cultural depreciation, and the state has an obligation to safeguard them, recognizing them as critical to the environmental, cultural, and spiritual well-being. Your Lordships, the right to life under Article 21 of the Constitution of India encompasses not only physical survival, but also the right to live with dignity. This extends to the protection of cultural heritage and traditions integral to human identity and societal values, thereby acknowledging that depriving citizens of their cultural environment undermines their fundamental rights. Your Lordship, the Supreme Court in the case of SCERC versus Union of India has observed, and I quote, the right to life with human dignity encompasses within its fold some of the finer facets of human civilization, which makes life worth living. The expanded connotation of life would mean the tradition and cultural heritage of a person's concerned. And in the current proposed project, my lords, the state risks eroding centuries-old traditional architecture and the socio-economic fabric of the city of Vrindavan and shaking the foundation that supports the pilgrimage economy. Moreover, your lordship, any deprivation of Article 21 must follow a procedure that is just, fair, and reasonable as held by the court in Maneka Gandhi versus Union of India. Indiscriminate demolition with inadequate consultation or rehabilitation, my lords, violates this procedural mandate. The state cannot prioritize infrastructural redesign without first ensuring that heritage considerations and cultural rights are balanced and preserved. Religious autonomy under Articles 25 and 26 of the Constitution, my lords, can only be restricted by public order, morality, and health, and require strict narrow construction. The physical site and architecture of worship are integral to these rights, and arbitrary state interference should be prohibited, my lords.
Did the court not take into consideration the state statement that all projected affected persons will be properly placed in proper place? Was it not considered by the statement was made by the state government?
Your lordships, indeed, but according to the
Then what
facts
is
of the case as
and
well,
land equity reference procedure also have to be adopted. And so
my
what is the
lordship,
answer to that? What
your
was wrong in
lordship,
that?
they
What was
haven't
wrong in
not been adopted.
the question is the court was considering two aspects. One, that the person who affected will be protected and be placed properly. And second thing is land equity proceeding also was to be adopted for the person who was going to lose their property and get the land equity. Then what was wrong in the order? Answer from that point of view.
Yes, your lordships. Your lordship, it is humbly submitted that the forced eviction of 200 families and displacement of around 500 small businesses was done without fair compensation or prior hearing, which contravenes with the statutory safeguards of the LARR Act, which requires transparency, participation, rehabilitation, and resettlement before acquisition or eviction.
That is a separate remedy available to the persons concerned, not in the PIL itself. Your remedy is available. If the state does not follow their own statements, if they're not doing properly, your remedy is available to you. You're not remediless.
Your lordship, but the procedure under which this project is being undertaken is unconstitutional. It infringes on the people's rights of Article 300A, which guarantees a due process. And questions of land ownership and the questions of land acquisition cannot be done without such. This has been again and again laid down by the Supreme Court, and as recently as 2024, in the case of Kolkata Municipal Corporation versus Bimal Kumar Shah, my lords, in which they reinforce that any deprivation of property must be met with procedural safeguards, which is enumerated as 7 rights in the judgment, and none of which have been provided to the petitioners, my lords.
Okay. You
If
can
I
continue. Yes,
if I
you
may-
can continue. Yes, you can continue.
Much obliged, your lordship. Your lordship, it is most humbly submitted that there is no automatic priority between public safety and religious or cultural freedoms, and the courts require independent justifications for every restriction and must harmonize rights to maximize utility of the limitations imposed. Your lordships, in the case of KS Puttaswamy versus Union of India, the court has affirmed the necessity of least restrictive measures in rights-limiting administrative actions. Your Lordship's 4-pronged proportionality test, as laid down in the Supreme Court in this case, requires administrative actions to serve 1, a legitimate aim, 2, a rational nexus between the measure and that aim, Third, a necessity with regards to the use of the least restrictive means and the equally effective alternative. And number four, my lords, balancing and proportionality strictly between rights cost and public benefits. Your lordship, it is not denied that there is a legitimate aim and the state has a duty to protect the public at large. However, the counsel for the petitioner humbly asserts that the state in the present case fails this test, as there is no rational nexus between the corridor plan and the aim of public safety. Less restrictive alternatives would achieve these required objectives, and the balance of proportions between the cost infringing on people's fundamental rights and public safety is unequal, my lords. The state has failed to show that the demolition is the only way to ensure safety, given the successful non-structural crowd management methods as at other major religious sites, my lords. Examples include, my lords, the Tirupati temple in Andhra Pradesh, where they have successfully managed 75,000 daily visitors with online darshan tokening system, RFID-enabled tracking, and CCTV monitoring. My lord, similar technology has been implemented in Mata Vaishno Devi temple and Sabrimala temple, that too without structural changes.
Similarly, in Vishwanath corridor also in Varanasi. It's been done.
Your lordship, but it is humbly asserted that the state has failed to show that less restrictive alternatives have been explored and thus exhausted before employing this intrusive corridor plan. Your lordship, similar alternatives have been suggested by the counsel for the petitioners in page 32, para 47 of our given memorial, my lords.
What are they? You can innovate shortly.
Yes, sir. So, yes, Lordship. So, this includes radio frequency identification enabled tracking systems, which use the phones of the devotees for real-time updates. And includes AI-powered CCTV monitoring for crowd management, counting the number of devotees at a certain time, and also for identification for lost persons, my lords. Additionally, there is also online darshan tokening system and staggered darshan timings, which allows the devotees to come at a particular time for the darshan to effectively control the crowd at a certain given point in time in the day, my lords.
When the crowd following pilgrims around 50 lakhs per day, how do you manage? I'm talking from the facts of the matter which will be narrated. If 50 lakh persons are attending on a particular day, how do you manage that? You have to have big corridors for them to go and do the darshan. What's wrong in that?
Your lordships, if we just implement an online darshan tokening systems where the devotees can book a time slot in which they are going to be attending or visiting the temple, then the crowd will automatically lessen from 50 lakhs at a time over a period of 2-3 days, or because the tokening system in itself would not allow more than a limited amount of bookings. Right. So automatically the crowd will automatically be limited, and they will be more organized, as there will only be a safe and manageable amount of devotees at a certain point in the precinct itself.
Madam, you're 100% right. I'm talking about a day when there's a public religious function on a particular day or religious festival. At that time, how do you manage the crowd? For that purpose, they are doing something. What's wrong in it? How is 136 affected? How is the order wrong under 136 in that light? Article 136. What powers do I use?
Your lordships, if I may,
I'm not against you. I'm just listening, giving opportunity. I'm not against you. I'm not made up a man. We are listening to you. But only question, we want certain answers from you. You are arguing 136. So 136, how does your case fall within 136 of the Constitution? Sir, you can continue. No problem. No problem. No problem. You can continue. No issues. No issues. You continue. No problem. No problem. No problem. You can continue. No problem.
Your lordship, it is humbly submitted that the Supreme Court has proscribed arbitrary demolitions in the past. State must observe strict adherence to due process, which is mandatory before any demolition, especially at a sacred religious space. Legislative safeguards such as the Ancient Monuments and Archaeological Sites and Remains Act of 1958 and judicial precedents like the Shiruri Mutt case provide special protection to religious institutions against arbitrary or disproportionate state interference. As previously submitted, my lords, minimally intrusive crowd management solutions such as AI-powered crowd density monitoring, RFID tracking, and online darshan booking, and other solutions as explained on page 32 and para 47 of the memorial offer comprehensive safety without demolitions, my lords. My lords, if the court is satisfied with the issue number 3, may I have permission to move on to issue number 4?
Oh, yes.
Much obliged, Your Lordship. Your Lordship, the counsel for the petitioner humbly submits that absence or inadequacy of public consultation renders the decision-making process arbitrary under Article 14, Your Lordships. The right to life enshrined under Article 21 of the Indian Constitution is a holistic right that goes beyond physical survival to include dignity, livelihood, shelter, and cultural rights. This right mandates that no individual shall be deprived of life or personal liberty except by procedure established by law that must be just, fair, and reasonable. Your Lordship, in the case of Chameli Singh versus State of Uttar Pradesh, while considering the right to shelter, the court has said, and I quote, the shelter for a human being is not a mere protection of his life and limb. It is a home where he has opportunities to grow physically, mentally, intellectually, and spiritually. The right to shelter, therefore, includes adequate living space, safe and decent structure, clean and decent surroundings, sufficient light, pure water, and electricity. Your Lordships, the Article 21 is intrinsically linked to Article 14, which guarantees equality before the law and prohibits arbitrary state action. Article 14 has evolved to impose a broad prohibition on arbitrary decision-making that affects fundamental rights, and therefore, the absence of meaningful consultation with affected parties renders any decision-making process arbitrary and unconstitutional under Article 14, my lords. My lords, for the consideration of the court, the counsel for the petitioners has divided each grievance by each aggrieved party as represented by the petitioners in the present SLP. If I may have the permission of the court to move on to the grievances as posed by the residents and the shopkeepers of the case.
Yes. Continue.
My lordship. Your Lordships, the forced eviction of over 200 families and displacement of around 500 small businesses, as submitted earlier, is without fair compensation or prior hearing and contravenes with the safeguards of the LARR Act, which requires transparency and resettlement before acquisition or eviction. Your Lordship, the recent Supreme Court guidance in the case of Kolkata Municipal Corporation versus Bimal Kumar Shah reinforces that deprivations of property must be met with procedural safeguards, namely 7 of them as listed as right to notice, hearing, reasoned decisions, acquisition strictly for public purpose, fair restitution and compensation, and a timely, efficient process prior to dispossession, none of which were observed by the state in the present matter, my lords. Proceedings against properties with informal, customary, or disputed titles, my lords. As mentioned in the facts of the case, there are certain properties under the plan which are being acquired, which have informal, customary, or disputed titles, my lords. These, without prior judicial adjudication, violate Article 300A's due process guarantee. And the question of land ownership, my lords, cannot be determined unilaterally by the executive authorities. This principle was stated by the court in the case of Ganesh Burman versus State of Jharkhand, where it is said that the doctrine of separation of power mandates adjudication of ownership titles must be done by the court prior to acquisition, my lords. My lords, I would like to move on to the contentions raised by the environmentalists of the Vrindavan.
If you see,
My lordship,
what did court observe? The court emphasized that safeguarding human life is a constitutional priority, and under Article 21, and that modernization of temple approaches was necessary to address the systematic risk. What was wrong in this? And tell me that. See, you are talking about land acquisition processing. All this is the subsequent part. This is the court is addressing itself to a PIL which has been filed by the people, saying that because of the stampede this has happened, so emergency measures should be taken. The court has passed an order, emergency measure to be taken subject to 1, 2, 3, 4, 5, 6. What is wrong in that part of it? That's what we want to understand. Your issue is correct.
Lordship,
You have
fourth
seen your
contain
issues. Issue are right. You're addressing rightly. Your fourth issue is correct on the correct issue. Little elaborate that. I have understood issue for, but just elaborate.
yes,
Elaborate. Yes.
certainly, Your Lordship. Certainly, Your Lordships. My lords, the court duty to protect under Article 21 is undeniable, but the method matters. In the case of Ram Jawaya Kapoor versus State of Punjab, my lords, this honorable court recognized executives' inherent powers in policy formulation, my lords. The High Court could have directed the state to ensure crowd safety through appropriate measures rather than mandating a specific infrastructural solution, my lords. This preserves Article 21's protection while respecting separation of powers. The end doesn't justify transgressing constitutional boundaries, my lords, and that is what the counsel for the petitioner humbly submits, my lords.
Correct.
If I may
Continue.
move on.
Continue. Yes. Yes. Continue. Continue.
Much obliged, Your Lordship. On the matters of environmental concerns, Your Lordship, the Banke Bihari Temple Corridor project is located 300 to 500 meters away from the front of the Yamuna River, exposing the river's sensitive ecosystems to risks of human activity, construction debris, sewage, and encroachment, all threatening water quality and ecological integrity, my lords. Statutory mandates, my lords, such as the Environmental Protection Act and the Environmental Impact Assessment Notification dated 14 September 2006 require completion of an Environmental Impact Assessment EIA and obtaining environmental clearances before project commencement, and failure to do so would amount to statutory and regulatory non-compliance, Your Lordship. Under Article 21, Your Lordship, the right to life covers right to clean and pollution-free environment as first recognized by this court in the case of Francis Corelli Mullin versus Administrator Union Territory of India, my lords. Additionally, my lords, as discussed in the case of MC Mehta versus Kamal Nath of 1997, my lords, the doctrine of public trust holds that the government is responsible for protecting natural heritage and for public welfare, my lords. Additionally, my lords, moving on to constitutional principles, the state's duties under Articles 48A and 51A subclause G reinforce environmental protection as enforceable fundamental rights, which courts recognizing environmental rights as absolute is essential to constitutional jurisprudence. It has been done as recently as in the case of M.K. Ranjit Singh versus Union of India in 2024, my lords, and goes back to the MC Mehta versus Kamal Nath case in the 90s, my lords. My lords, additionally, the last group of aggrieved parties comes to the heritage conservationists, my lords, as represented by the petitioner. My lords, the project's demolition of over 300 structures within heritage protected zones of Vrindavan threatens irreversible damage to cultural fabric of Vrindavan, my lords, including sacred alleys, pilgrimage routes, and protective monuments, fundamental to the region's religious identity, my lords. My lord, sections 20A and 20B of the Ancient Monuments and Archaeological Sites and Remains Act, my lords, strictly prohibit construction or demolition within 100 meters of protected monuments without prior approval and regulate activity within 200-meter radius of the protected monument, my lords. Additionally, my lord, section 20A, subsection 3, clause B mandates that any permitted construction within these restricted zones must not materially alter the monuments, and the reasons must be recorded in writing with the ASI director, my lords.
But
Moreover, my lord,
when the respondent made a statement before the court that environmental and heritage claims will be duly complied with accordance with the Environment Act and the Prevention of Control Pollution Act and Ancient Monument Archaeological Sites and Remains Act 1958. They have already made a statement. Whether they comply, don't comply, then your remedy might arise. Okay, they have not done in spite of statement.
my
This
lord,
statement made by them.
my lords is humbly submitted that the project has already commenced. Land acquisition and construction has already commenced, and these statutory mandates are supposed to be complied with before such action is taken.
Have you challenged that aspect? No.
Yes, Your Lordship. It is stated that the environmental clearances, as in the Environmental Protection Act and the EIA notification dated 14 September 2006, that the environmental clearances must be obtained before the project commencement, and failure to do so would amount to regulatory non-compliance.
Okay.
Additionally, my lords, the Ancient Monuments and Archaeological Sites and Remains Act of 1958 also requires, especially in section 2820B, that there must be prior approval to make construction or demolition in the prohibited zone, which is 100 meters from the protected monuments, and the regulated zone, which is within 100 meters to 300 meters within the radius of the protected monuments, my lords. My lords, lastly, I would like to humbly submit that Section 20A, subsection 4, bars granting new permissions for construction except through the permission of the central government or the Director General of the Archaeological Survey of India, which was affected post the amendment of 2010, my lords. So, effectively, there is no new permission to be granted for any sort, there's an explicit bar or any new permission to be granted for construction within these zones post 2010 minus, save for the authority of the central government or the Director General of the Archaeological Survey of India, my lords. My lords, this principle also emphasized by the court in the case of Nahata Traders and Builders Private Limited versus Director General ASI, which was of 2010. That said that strict procedural compliance must be made and rejected the delegation of approval authority to entities other than the central government or the Director General of the Archaeological Survey of India, my lords. The current order by the court and the court judgment in the present case would not suffice as substitute to these two necessities of the provision, my lords. With that, my lords, if I may have permission of the court to submit the prayers.
Yes.
Much obliged, Your Lordship. Your Lordship, the counsel for the petitioners would like to humbly and respectfully pray that this honorable court be pleased to adjudge and declare an injunction for the continuation of the project to protect fundamental rights as conferred under the Constitution of India, and declare any other reliefs that this honorable court may be pleased to grant in the interest of justice, equity, and good conscience, my lords. With that, Your Lordship, the counsel for the petitioner would like to rest their case.
So you're not seeking any declaration that the order is bad in law should be set aside. The order directing mandamus should not be set aside. That's not your
Your
prayer.
Lordship, the comprehensive prayers have been provided
No,
as
provided. Okay, so that's why you're asking for interim prayers.
yes, Your Lordship.
Okay,
Your
okay,
Lordship, okay.
fine. Okay, fine.
Much obliged, Your Lordship. Shivam, sir, you're on mute.
With permission of my lordship, now I request the counsels of respondent to kindly proceed for the arguments before the honorable bench.
Yes. Greetings to the bench. The counsel seeks permission to approach the dais.
I can't see that.
Are we visible, Your Lordship?
No, I can't see it. Not clear. Visibility on the video also is not proper and I can't see you. It's stand still.
Lordship, I can hear you.
No, I can see you, but your photograph is moving. It's not. It's a standstill photograph. It's not moving around. I can hear you properly. Your voice is cracking. In fact, try to argue. Let me see.
Your Lordship, now
no,
is it?
no, it's cracking completely. I could hear the petitioners clearly. I can hear you clearly. Adjust a video or something, let's say. Or log out and log in again.
Your Lordship, now?
Yeah, I can hear you now.
Are we audible? Okay. Greetings to the bench. The council seeks permission to approach the dais.
Yes, continue.
Much obliged, Your Lordship. May it please the Honorable Court that the council representing the respondent side in the case of Govindas versus State of UP. With due permission of the bench, the council would like to proceed with the issues, Your Lordship.
Continue.
Much
Proceed.
obliged, Your Lordship. Your Lordship, the first issue in hand is whether the High Court mandamus under Article 226 directing a particular corridor scheme amount to impermissible micromanagement of executive policy or is constitutionally valid exercise to remedy systemic failure endangering life and safety. Your Lordship, the mandamus issued by the Allahabad High Court under Article 226 was not executive encroachment, but a constitutional safeguard, Your Lordship. It was meant to protect the paramount right to life under Article 21, Your Lordship. Your Lordship, in the case of L. Chandra Kumar versus Union of India, 1997, this Honorable Court held that whether the executive fails to discharge constitutional obligations, the courts are empowered to issue directions to secure effective governance, Your Lordship. Further, in the case of Bandhuwa Mukti Morcha versus Union of India, 1984, the court ruled that the judicial directions under Article 32 and 226 can compel the state to act where life and dignity are endangered under Article 21, Your Lordship. Here, the Bake Bihari Temple stampede of 19 August 2022 showed a systemic failure. The High Court mandamus was not arbitrary intrusion, Your Lordship, but a corrective step to ensure preventive measures, Your Lordship. Your Lordship, further moving ahead, on page number 15, point number 1.2, which states that the principle of proportionality strongly supports the High Court directions, Your Lordship. Your Lordship, in the case of Om Kumar versus Union of India, 2001, the Honorable Court held that the state action affecting the fundamental rights must be reasonable and necessary. The corridor projects here represents a proportionate response to the serious risk posed by congested temple precincts, Your Lordship. Your Lordship, the proposed alternatives which were mentioned by the petitioners, like staggered darshan timings or technology-based crowd control, cannot address the structural deficiencies of narrow alleys and centuries-old buildings, Your Lordship. With over 50 lakhs pilgrims annually, only a structural intervention ensures safe movement and emergency access, Your Lordship. Your Lordship, further moving ahead, in page number 16, point number 1.3, which states that the claim of judicial review is incorrect, Your Lordship. Separation of power is flexible, allowing the judiciary to act when executive inaction threatens fundamental rights, Your Lordship, especially the right to life under Article 21, Your Lordship. Your Lordship, while executive, legislative, and judiciary functions are constitutionally distinct, the Supreme Court has consistently held that the judiciary may intervene when the executive fails to discharge its constitutional duties or inaction threatens the fundamental rights, Your Lordship. Your Lordship, in the case of State of Himachal Pradesh versus Umid Ram Sharma, 1981, the Honorable Court held that the judiciary is empowered to compel the state to perform its duty where executive inaction comprises the right to life, including access of safe infrastructure, Your Lordship. Further, in the case of Supreme Court Advocates on Record Association versus Union of India, 1933, it was affirmed that separation of power is flexible in India, Your Lordship, and judiciary may issue appropriate direction to ensure that constitutional values are upheld, Your Lordship. Your Lordship, in page number 17, point number 1.4, which states that constitutional measures and the High Court obliges the state to protect individuals not merely from arbitrary deprivation of life, Your Lordship, but also from foreseeable hazards, unsafe environmental and structural dangers, Your Lordship. Your Lordship, in the case of K. Krishnamurthy versus Union of India, 2010, the court repeated that constitutional interpretation must prioritize the preservation of life, dignity, and safety over competing considerations, Your Lordship. Your Lordship, on page number 18, point number 1.5, which states that the Bake Bihari Temple Corridor project ensures public safety without compromising Vrindavan's religious and cultural heritage. The project introduces controlled entry, wider circulation routes, and emergency exits, Your Lordship, addressing life-threatening congestions while preserving the spiritual environment, Your Lordship.
If you are going to do this aspect, then where is the question of demolition? If you are going to protect in this manner which you are giving, then why you want demolition?
Your Lordship, your Lordship,
Just now you set out some procedure which you want to follow. Then why do you require
your
demolition?
Lordship, Your Lordship, wherever is something under construction, we need to block something in order to achieve a greater goal, Your Lordship. We are initiating and executing this project for the devotees itself, Your Lordship, and this project will benefit them only.
No, I'm on different
And
thing.
Your Lordship, be assured.
You just now said that you are going to do 1, 2, 3, 4 items. If those 1, 2, 3, 4 items are going to protect, then why do you require demolition?
Your Lordship, the demolition of 300 structures are premature, Your Lordship. The project is still in preparation. Compensation for effective. Yes, Your Lordship.
No problem.
Yes, Your Lordship. Your Lordship, the Baki Bihari Temple Corridor project ensures public safety without compromising Vrindavan's religious and cultural heritage, Your Lordship. Your Lordship, in the case of Rajiv Mangotia versus Secretary of the President of India 1997, the court held that heritage preservation must adapt to modern needs to avoid hazards, Your Lordship. Further, in the case of TN Education Debt versus State of Tamil Nadu,
Your voice is cracking.
point number 1.5, it states that recognize that modernization in public interest can coexist with cultural preservation, Your Lordship. Your Lordship, here the project removes only unsafe bottlenecks, preserves traditional aesthetics, and safeguards life under Article 21 while respecting Article 25 and 26, Your Lordship. The High Court mandamus demonstrate that public safety, heritage protection, and devotional practice can coexist, making the intervention constitutionally valid and culturally sensitive.
Dear
Lordship.
Yes, dear counsel, does the phrase
The counsel-
public order? Yeah. Are you hearing me? Am I audible?
Yes, Your Lordship.
Okay. I have a question.
Yes, Your Lordship.
You're talking about this phrase?
Yes, Your Lordship.
Right now, you talked about the phrase. Does the phrase public order, morality, and health in Article 25, 26
Yes,
permit? Does this permit permanent alteration of heritage
Yes.
structures?
Your Lordship.
I repeat my question.
Like
I repeat my
submit,
question.
we are not opposing.
Madam, just listen to the question my
Yes,
brother
Your
is
Lordship.
asking you. First, listen to the question he's
Your
asking you.
Lordship, am I audible?
Yes,
No,
yes.
you're not. Yeah. Just listen to the question which is putting to you first.
Okay, my question is, does the phrase
Your
public
Lordship,
order?
am I audible?
Yes, you're audible.
No. Yeah. Your Lordship, I would like to state that we are not opposing the ERP doctrine, Your Lordship. Nor we are denying.
Madam, first listen to what the court is asking you. First understand the question
Yes, Your
with
Lordship.
my brother judge, then you decide. Then you answer that. But first listen to what he's saying. Understand the
Your Lordship,
question
you
first.
do
My
network-
strict caution, my strict caution to you is, does the phrase used public order, morality, and health in Article 25 and 26, does this permit permanent alteration of heritage structures,
No, Your Lordship,
which
they
are
doesn't
ASI
permit
protected, according to the
Your
petitioner's part?
Lordship, according to Article 25 and 26, the court's judgment only held that the secular aspects of the which are part of regulation, they can be regulated for the purpose of public safety, Your Lordship.
Is
in
there
public
is there
interest.
any judgment of any court
Yes, Your
which
Lordship.
answers this question, that these articles permit permanent alteration of heritage structures? I'm using the particular word, which are ASI protected, according to the arguments given by the petitioners.
Your Lordship, we are not opposing that heritage conservations or any monument.
I'm talking about the alteration or destruction of those heritage structures. Is it in the 25 or 26 under public order, morality, and health, the phrase that you used?
Your Lordship, I would like to state a case law for this. In Ismaili Faruqi versus Union of India, 1994, Your Lordship clarified, Your Lordship, it is where clarified that while the right to worship is protected, the place and manner of access can be regulated for public order and administration, Your Lordship. This project regulates only the secular aspects, not core religious practices, and is fully permissible, Your Lordship. Your Lordship, with that, in the case of Muhammad Hanif Qureshi versus State of Bihar, 1958, the courts ruled that non-essential practices, even if long followed, may be regulated in public interest, Your Lordship. Your Lordship, here the width of alleys or circulation routes cannot be deemed essential practices of the Pushti Mark traditions, Your Lordship. The true essential is darshan of Thakur Shri Bake Bihari Ji, which remains untouched. Is the freedom of religion, but it is expressly made subject to public order, morality, and health, Your Lordship. Therefore, when the exercise of religion or the existence of the structure itself threatens the public safety order.
Okay. Are you aware about the fact that they are going to destroy the ASI protected temples, but Bake Bihari is not the ASI protected ones? There are more than 15 temples. They are going to desecrate them. So does it come under public order, morality, and health clause under Article 25 and 26? This is not about Bake Bihari.
Council will be dealing that.
In this corridor project, many temples are going to be destroyed. They're going to be desecrated and altered, and they are ASI protected temples. So my question is very simple. Does the phrase you used, public order, morality, and health, this is what the crux of your whole argument, I think. In Article 25-26 permit permanent alteration of heritage structures under the groove of some other temple.
Lordship, but it is a fateful facilitation, not an interference, Your Lordship. Your Lordship, the Bake Bihari corridor project is not interference. The devotees can perform darshan of Thakur Shri Bake Bihari Ji in a safe, orderly, and dignified manner, Your Lordship, consistent with the state's duty under Article 21, Your Lordship. Your Lordship, in Khazamian Waqf State versus State of Madras, 1970, safety measures in religious institutions were upheld as valid regulations, not interference, Your Lordship. Your Lordship, here rituals, deity worships, and priestly services remains untouched, Your Lordship. The project only widens the alleys, creates holdings, areas, sanitation, and emergency facilities, Your Lordship. Measures to prevent the tragedies like the 19 August 2022 stampede. Thus, my lords, far from restricting religions, the project enhances the devotional experience of making it safe and secure, Your Lordship. Your Lordship, the right to life is the ultimate issue here. 2 deaths and 25 people under critical care. This evidence in itself makes this project urgent, Your Lordship. The alternatives, even if we apply here, are not solving the inadequacy, Your Lordship. Happened. This root cause not solved at the early, and end up taking more lives of the patient. To proceed.
Dear Councillor, I'm unable to hear you.
We can hear you.
You can continue.
Lordship, the Council seeks permission to proceed with issue number 2.
Proceed, please.
Much obliged, Your Lordship. Your Lordship, the second issue in hand is whether the reconfiguration of temple approaches, alleys, and religious circulation routes implicates Article 25 and Article 26, and if so, the correct test to distinguish fateful facilitation and unconstitutional interference, Your Lordship. Your Lordship, page number 20, point number 2.1, which states that religious autonomy cannot mean the immunity from regulation that protects public welfare, Your Lordship. Your Lordship, in the case of Acharya Jagdishwaran versus Commissioner of Police, Calcutta, 1980, clarified that the court practices not essential to religions may be regulated in the interest of public safety, Your Lordship. Your Lordship, likewise, in the case of Adi Seva versus State of Tamil Nadu, 2019, states that clarified that essential practices are protected, but secular aspects of temple management remains open to regulations, Your Lordship. Your Lordship, applying this, devotees still perform darshan, priests still render seva. The project only reconflicts and circulation routes and infrastructure, Your Lordship. Purely secular aspects directly tied to safety and accessibility. Thus, the project falls within the within constitutional limits under Article 26, Your Lordship. Your Lordship, on page number 20, point number 2.2, which states that it is a fateful facilitation and not an interference, Your Lordship. Your Lordship, here the rituals, deity, and worship of priest services remains untouched. The project only widens the alleys, creates holding areas, sanitations, and emergency facilities, measures to prevent tragedies like the 19 August 2022 stampede. My Lord, far from restricting religions, the project enhances the devotional experience by making it safe and secure, Your Lordship. Your Lordship, the corridor project provides wider alleys, control routes, and emergency exits, structural safeguards that protects life while allowing worship to continue safely, Your Lordship. Thus, the project is constitutionally valid, measures that upholds public order and health without interfering with ritual or doctrines, Your Lordship. Your Lordship, further, on page number 20, point number 2.5, which states that Article 25 cannot be read in addition. It must be harmonized with Article 21, the right to life and safety, Your Lordship. Your Lordship, in the case of TMA Pai Foundation versus State of Karnataka 2002, Your Lordship clarified that fundamental right must be balanced against each other. Here, the worship at Bake Bihari Temple cannot be divorced from the safety of lakhs of devotees, Your Lordship. The stampede of 19 August 2022 tragically showed how unregulated worship in unsafe alleys compromises Article 25, Your Lordship. Your Lordship, I would like to request my co-counsel to deal with issue number 3 and 4, Your Lordship. The counsel seeks permission to approach the dais.
Permitted.
Continue, permitted. Yes.
Much obliged, Your Lordship. Your Lordship, the issue in hand, whether the state's objective of the crowd management, public safety under Article 21 justify large-scale demolition, demolition and redesign of an organically evolved sacred precinct when less restrictive alternatives are available. Your Lordship, please refer to memorials page number 26, issue number 3.1. Your Lordship, a very tragic stampede happens on 19th August 2022. Your Lordship, in which 2 deaths happens and 25 people get injured very critically, Your Lordship. And the reason being the reports, according to the reports, the reason being the structural inadequacy, Your Lordship. Your Lordship, unless the structure is fixed, any sort of alternatives being prescribed by the side of the petitioners will only be going to be giving the solutions and the palliative measures, Your Lordship. It is only be giving the solution that temporary period, Your Lordship. Your Lordship, it is just like a person's having a cancer in their body and they're going to the dermat for the hair loss, Your Lordship. If the cancer is not solved, the hair loss cannot be solved. Similarly here, Your Lordship, the structural inadequacy is the cancer here. It is the main issue here. If the root cause is not solved, Your Lordship, the structural inadequacy is not solved, no matter how much alternatives we apply, the stampede-like activities cannot be prevented, Your Lordship. Just because of this fact, Your Lordship, the state's project directly addresses this with emergency exits, medical facilities, crowd regulation, sanitation, without even touching the doctrine of worship, Your Lordship. Is held in the Mohinder Singh Chawla, 1997, Your Lordship, the state has a positive duty under Article 21 to protect life. Your Lordship, last paragraph, please refer to page number 28 of the memorial, Union Carbide case. It was held. Even the alternatives may exist. The authorities may adopt the reasonably evidence-based measures to mitigate the imminent risk. Your Lordship, here 2 deaths which has happened. The 25 people who have gotten injured, they itself is a imminent and empirical evidence for the structural inadequacy to become structurally adequate. We are not denying the alternatives provided by the petitioners are not good. Your Lordship, if the petitioners are applying the alternatives on problem which is not solving the core issue, the stampede-like activities which will not be prevented, Your Lordship. Your Lordship, hence the action, the state is necessary and fully lawful, Your Lordship. Your Lordship, please refer to page number 8, issue number 3.3, Your Lordship. Your Lordship, essential religious practices. Parikrama around the sanctum is fully protected, Your Lordship. Here, the state is not banning the parikrama, Your Lordship. The state is not even changing the routes of the parikramas, Your Lordship. Here, the simple thing is done, that is widening of the alleys that is happening, Your Lordship. Your Lordship, here, the widening of the alleys, which basically provides the state, or which basically provides the devotees a basic safeguard for their lives when they're coming for the darshan to the temple, to darshan of the Lords. This basically provides them a safer access to the God, Your Lordship, to the devotees. Here in the section 25, clause 2, subclause A, Your Lordship, the state is empowered to regulate secular activities associated with the religious, Your Lordship. In Commissioner of the Police versus Acharya Jagdish Varandanam, Avadhuta, 1992, Your Lordship. The court held that the state may regulate crowd management, traffic, and sanitation around the religious institution without infringing the religious right, Your Lordship. And here, the religious rights are not at any extent are getting violated, Your Lordship. Hence, the religious aspect is devotion and parikramas, which is the secular aspect, Your Lordship. It is ensuring pathways are wide and orderly, and state action protects the life without affecting the sense of the worship, Your Lordship. Your Lordship, here, my co-counsel from the petitioner side has mentioned about the Tirupati temple, Your Lordship. Tirupati temple, Your Lordship, has built on a already structural adequacy, Your Lordship. Here is compared to the Baki Bihari temple, Your Lordship, which is in the still proposal act and under planning act, Your Lordship. Corridor is not fully yet functional. Many amenities still in plan, Your Lordship. So Tirupati temple's infrastructure is more operational, and versus Baki Bihari perspective, Your Lordship. Your Lordship, here all the alternatives that are contended by the petitioner sides all are backed by the structural adequacy, Your Lordship. Your Lordship, here my co-counsel from the petitioner side also mentioned about the Vaishno Devi temple, Your Lordship, which is actually a misplaced fact, Your Lordship. Vaishno Devi temple is where it is situated at the shrine area. It's situated at a hilly area. Your Lordship, alternatives like ropeways, ponies, choppers, everything is available there. The crowd which goes there is different, and the crowd which comes to the Vrinda Baki Bihari temple is different. In contrast, Your Lordship, Baki Bihari are crowded urban area with the devotees mainly senior citizens, Your Lordship, entering the narrow lanes, which is 2-3 meter wide alleys. And unlike the Devi staggered darshan, Your Lordship, Vrindavan sees a sudden crowds of the lakhs during festivals. In such condition, RFID cannot manage the rush. Widening of the safer parikrama measure is secular and associated with the religion itself, Your Lordship, under Article 25. Your Lordship, in the memorial of the petitioners, it is mentioned about the mobile alerts, Your Lordship, in the section of the alternatives that are available. Your Lordship, if this alternative is available and if this applied to the respondent side, the devotees, and the application has been put into the people's mobile phone regarding the mobile alerts, Your Lordship, it can still cause the stampede when at the same time all the people's phone, all the devotees' phone are going to be ringing at the same time regarding the mobile alerts. It's going to create a situation like stampede again, Your Lordship. Your Lordship, my co-counsel also mentioned about the structure demolition 300 structural demolition, Your Lordship. Your Lordship, here the 300 structure that are demolishing, that the claim is being done, Your Lordship, here the demolition is not happening. The project has still not yet started, Your Lordship. It is in the preparatory stage. Before we could do anything, before we could do or take any actions, before we could provide a notice for the land acquisition or public consultation, Your Lordship, it is point to be noted that in April 2024, petitioner went to the Supreme Court before we could take any action at point of time, Your Lordship. Your Lordship, here the 300 crores rupees has not been spent yet, Your Lordship. It is still with the government. Your Lordship, here it has been earmarked for the potential implementation, covering the future land acquisition, architectural surveys, and the fund remains under the control of the state, Your Lordship, and for part of the plan.
What happened in Supreme Court? You said you had gone earlier.
Your Lordship, in the statement of fact, it is just mentioned that they went to the Supreme Court for the order to went on state.
Okay.
One more question.
Yes, sir.
Counsel, one more question.
Yes, sir.
Why you only target this temple? Because the crowd pressure is on every temple. There are many temples in Vrindavan, like ISKCON temple is there, like Akshapatra is there, like Prem Mandir is there. crowd pressure is on everywhere, on every temple. So why you selectively targeted this temple only? So isn't it a violation of Article 14? And see, the state is
Indeed not,
not
Your
God.
Lordship.
Should I repeat my question?
Yes, indeed, Your Lordship.
Okay. I just want to, the state is not God, it's God's instrument, bound by reason, answerable to conscience. I just want to ask you, you simply targeted a Bhagya Vihari temple, while the crowd pressure is everywhere in Vrindavan. You might have heard about ISKCON temple, this one, Akshay Patra, Prem Mandir, crowd management is everywhere. So why not a comprehensive Vrindavan corridor? Why this selectively you are targeting Bhagya Vihari corridor?
Your Lordship, the temple is not selectively targeted here. Your Lordship, ISKCON temple that you have mentioned, Your Lordship, it has a very adequate infrastructure in its nature, Your Lordship. Even if, for that matter, for example, 75,000 devotees are coming to the ISKCON temple daily basis, Your Lordship, here in the Vrindavan Baki Bihari temple, every day 13,700 approximately devotees are coming. But the infrastructure which is inadequate in nature, and when the infrastructure, according to the report which has come out as becoming inadequate, becoming the reason for the stampede-like activities, Your Lordship, stampede-like incidences, Your Lordship, due to which the Baki Bihari temple is being getting reconfigured and getting renovated, Your Lordship, so that it provides a basic safer access to the people. That is why it is not a violation of the Article 14, Your Lordship.
Okay, proceed.
Indeed, Your Lordship. Much obliged, Your Lordship. Your Lordship, please refer to issue number 3.6 as it is affirmed in the Rajiv Mankotia's case, Your Lordship. The state may regulate such secular activity without affecting worship, and the project also preserves the temple's character, environment, and include phase rehabilitation in line with the Union of India versus SR Chaudhary case, Your Lordship. In short, the corridor project safeguards a life, maintain religious practices, and preserves the temple, making the state's action lawful, proportionate, and necessary under Article 21, Your Lordship.
My lord, I'm sorry to
Your Lordship,
interrupt the court. Only 5 minutes left for the petitioner. Oh, sorry, for the respondent. Only 5 minutes.
may I proceed with issue number 4, Your Lordship?
Yes, proceed, please.
Your Lordship, my co-counsel on the petitioner side mentioned about the Yamuna's river deterioration, Your Lordship. Your Lordship, it did not begin with this project, Your Lordship. Long before the corridor was even conceived, devotees, residents, shopkeepers been discarding this idols, flowers, food waste, plastic directly into the rivers, Your Lordship. And so held the project responsible for the river current state is actually misplaced, Your Lordship. Your Lordship, the project hasn't even been started yet. It's still a preparatory stage. Surveys and designs are ready, but before execution could begin, the petitioner themselves approached the Honorable Court and obtained the interim stay there. And naturally, no work could be proceed thereafter, Your Lordship. And now, assuming the moment for their procedural lapses, partial non-compliance with the EIA, it does not vitiate the process itself, because, Your Lordship, the Honorable Court itself in the Supreme Court in the Union of India versus Prabhakar Vijay Kumar 2008 held that procedural lapses do not invalidate the urgent state action aimed at protecting and saving lives, Your Lordship. And here too, Your Lordship, the very purpose of this project is a public safety and environmental protection, Your Lordship, to prevent the future tragedies, and to create proper sewage system for the waste disposal, Your Lordship. So even if there are any minor procedural deviations, Your Lordship, they cannot outweigh the larger public interest the project seeks to serve, Your Lordship. Your Lordship, please refer to page number 34 of the memorial, issue number 4.2, Your Lordship. It is important to note that the project is still in the preliminary stage, Your Lordship, and no land has been acquired yet. And therefore, the argument claiming the violation of the public consultation does not arise, Your Lordship. Your Lordship, here, even if the public consultation were not conducted at the stage, it does not and cannot invalidate the project, Your Lordship, as recognized in the Supreme Court in Bangalore Medical Trust versus B.S. Modappa and Narmada Bachao Andolan versus Union of India. Court has repeatedly held that the consultation is desirable but not constitutionally mandatory, Your Lordship, and where the state acts legitimate public purpose based on the expert studies, evidences, and urgent necessity, Your Lordship. And hence, the state acted on the urgent safety concerns, Your Lordship, regarding on architectural surveys, technical assessments, interdepartmental coordination, preparedness for the future implementation, not literary expenditure or the displacement, Your Lordship. Your Lordship, please refer to page number 35 of the 4.3 issue. Your Lordship, I respectfully submit that the respondent's action fully satisfy the Article 14 of the test of reasonableness, Your Lordship. The state taken only preparatory measures, Your Lordship. Expert studies, safety audits, compliance with the judicial directions, not final execution as yet done, Your Lordship. The step demonstrate due diligence, rational planning, as recognized in the Balco versus Union of India case, para number 2, please refer to para number 2, page number 35, Your Lordship, and the alignment with the principle against the arbitrariness in E.P. Royappa and Ajay Hasya, Your Lordship. Further, the state of the Gujarat Shri versus Shri Ambika Mills in the 4th paragraph mentioned this honorable court clarified that Article 14 permits reasonable classification based on the intelligible differentiate and rational nexus, Your Lordship. And here the affected person got identified due to the structural vulnerabilities, Your Lordship. And here, even at the same time, Your Lordship, Allahabad High Court has upheld the reasonableness of the state action. And no right are being diminished, Your Lordship. And that's why that project remained at the preliminary stage, ensuring the public safety without any irreversible execution, Your Lordship. Your Lordship, the council would like to conclude the statements. Your Lordship, in conclusion, the respondent has acted fully in accordance with the Constitution regarding issue 4.2. All preparatory measures, consultation, due process have been undertaken, Your Lordship, to ensure the transparency, fairness, protection of affected person addressed even at the preliminary stage, Your Lordship. With the respect to 4.3 issue, the state's action satisfy the test of the reasonableness under Article 14 as upheld by the Allahabad High Court as enforced by the precedents such as Balco, E.P. Royappa, and State of Gujarat versus Shirur Ambika Mills. Every step has been guided by the expert safeties and safety audits, Your Lordship, and rational classification addressing the public safety risk without infringing anyone's fundamental right, Your Lordship. Your Lordship, even at the time of the emergency, the mentioned case by the petitioner cites case put to Swami, Your Lordship, even at the time of the emergency, Article 21 and Article 20 are the fundamental rights which are untouched, Your Lordship, and rest of the rights can be set aside. Your Lordship, in the constitutional jurisprudence itself, Article 21 is been given is been considered the highest right in the hierarchical order, Your Lordship. Your Lordship, thus, my Lord, the state conduct in both procedurally sound and substantially reasonable, and no irreversible or arbitrary action has been taken yet. The project remains at the preliminary stage and ensuring that the public safety process, equality under the law are fully respected, Your Lordship. Hence, Your Lordship, we sincerely regret that the petitioner failed to see the broader picture that we have tried to present over here. Our concern is the safety and access of the devotees. A judgment in their favor at this stage may prevent the thousands of the devotees to perform the darshan, Your Lordship, which would not serve the justice. And we humbly submit the project should be allowed to proceed with the safeguards. Your Lordship, council will be proceeding with the prayer, Your Lordship. Your Lordship, therefore, in the light of the fact submission made herein above, it is most respectfully prayed that the Honorable Court may be pleased to dismiss the present petition, being devoid of the merit, uphold the validity and necessity of the Baki Bihari Corridor project, and recognize that the state acts within the constitutional statutory mandate, ensuring public safety and orderly management of the pilgrims, and pass any other order, decree, or judgment at this Honorable Court may fit in the light of the justice, equity, and good conscience, Your Lordship.
Thank you very much, Council. With this oral pleading for the semi-final round of First National Moot Court Competition 2025 has been concluded. Now I request the respected bench to kindly announce the results for the semi-final round.
Sir, if I
After-
may, there was also a section of rebuttals.
With the permission of the bench, if we could
Yes.
submit
If the,
rebuttals.
sir, if my lords would permit me to ask some questions to the council for the respondents, my lords.
It must not take more than 5 minutes, the whole process, question and answer.
Certainly, my lords, certainly. my lords.
Where is the question of you asking council any questions?
Sir, we are
Opposite
just-
side can't ask any question to other side. Sorry, you can rejoin if you want to say something on facts which they have said. You can't ask any question to other side.
Certainly, my lords. My lords, it will be just stating
Whatever they have said, if you want to rejoin on facts something, you can surely say.
Certainly, my lords. Certainly, my lords. Much obliged, my lords. My lords, although there have been a lot of contradictions in itself in the speech of the respondent, the most glaring contradiction that I would like to point out here is that they state that no arbitrary measure or no measure
Please
at all
conclude this within
has,
5 minutes.
yes, sir. No arbitrary measure or measure at all has been taken. My lords, they state that 300 crores have not been spent yet. Whereas, my lords, in their own written submission on the statement of facts, which is at page 10 of para 6, they states that the 300 crores have already been spent on land
You're
acquisition.
right. It says so. It says
Secondly,
so.
my lords, secondly, they state that the point of pollution of river Yamuna does not start with the demolition of the corridor and the demolition of the architecturally significant architecture, my lords, but it has been done by the people through their worship, my lords. My lords, are they contending through this that the state action thus do not pollute it further at all, because the people by themselves have polluted the river Yamuna to the extent that it could have been polluted, my lords. Therefore, we need to disregard all environmental concerns that are here, my lords. My lords, thirdly, they argue that Article 226 confers expansive power. But, my lords, doesn't Article 226, like anything else in the Constitution, have its own limits? Limits, my lords. Isn't there a difference between issuing mandamus to perform duty versus prescribing how that duty should be performed? How do you specify the corridor's direction, my lords? Lastly, my lords, the most weight has been put by the counsel for the respondent on Article 21. My lords, the counsel for the petitioners would like to state that there is no hierarchy of fundamental rights requiring one to trump another. Both Article 21, my lords, and 25 and 26 are fundamental rights requiring harmonious interpretation. My lords, the Constitution, there is no necessity to bring in 21 because the Constitution itself permits regulation of public order, morality, and health under 25 and 26 themselves. However, my lords, can such regulation be done if they do not strictly specify the constitutional test which we have given, which is compelling state interest, proportionality, and least restrictive means, two of the three which were absent in this case, my lords. My lords, with that, the counsel for the petitioner would like to rest its case, my lord.
Okay. Thank you.
Okay.
Speaks, Your Lordship.
Much obliged, my lord.
Now, how do we give the my learned brother is there? I am here. So how do we go about? What I suggest is, can we exchange on the phone the
Right,
marks?
Yeah.
Please.
That can be.
So I'll
Your
do
Lordship,
one.
may I please?
The whom do I
May I please-
address? Where whom do I the
We
marks?
are again joining this in 2 minutes, right?
Your
Yes.
Lordship, may I please
Sure.
reply to the
No,
petitioner?
there's no rejoinder now. No rejoinder. Thank you.
Thank you.
Sir, please join after 2 minutes for the results. All the teams.
So we leave and then rejoin in 5 minutes?
I and my
Yes.
brother will continue. Rest will leave.
All right. Thank you.
Thank you, sir.
Thank you, sir. Thank you.
Am I audible to all?
Yes, sir. Yes, sir.
You all of them did very well. You argued well. So, my dear young friends, it's privilege to participate in this discussion. And the problem with before you, the Vrindavan corridor case, my dear friend, is not a mere hypothetical. It is a meditation on the living conflict between faith and fundamental rights, between development and devotion, between the temple and the republic. Our constitution, in its majestic balance, gave us both Article 21, the right to life, and Article 25, 26, the right to worship. It commands us not to choose between them, but to harmonize them in humanity and the reason. So you all argued well. My suggestion to you is, when you raise to argue today, do not argue for victory, argue for truth. And I had a discussion with my brother, Jez, to give you the score. And the scores are as such: petitioner number 1, 60 marks. Petition number 2, 65 marks. Respondent number 1, speaker number 1, 50 marks, and respondent number 2, speaker number 2, 55 marks. Am I clear? Audible?
Yes, sir. Yes, sir.
Audible, sir. Audible.
Should I
Yes.
repeat? I had a discussion with Deepan sir, and petition number was 60 marks, petition number 2, 65 marks, respondent number 1, 50 marks, and respondent number 2, 55 marks.
Thank you, sir.
Thanks. You all argued well, right? And remember, when you raise to argue today, do not argue for victory, argue for truth. Best of luck, my dear friends. Right?
Thank you so much.
Thank you, sir.
so
Thank you
much,
for your
sir.
participation.
Good job by everyone. These marks are not only for the purpose of winning or losing. It's only a competition we have to give marks. All of you did a good job. So it's no problem. Your preparation was good.
Thank you, sir.
Thank you. Thank you for,
you
sir.
so
Thank you
much.
for your participation, sir.
Thank
Welcome.
you. Thank you. Thank you. Good day.